Hello, everyone. I see that we're at 12:01 Central Time, so we'll go ahead and begin our webinar. Hello, my name is Elizabeth Samples. I'm Senior Counsel in Husch Blackwell's Higher Education Group. We're very happy to have all of you here with us today. Before we begin, I'd like to cover a few housekeeping items. If you have any questions during the webinar, please submit your questions via the chat box. We'll do our best to try to monitor the questions and address them as we can. But if a fuller answer is needed, we'll also try to respond by email and follow up with you that way. We do truly appreciate your participation and encourage you to submit questions as you have them. This program has been approved for continuing legal education credit. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast as soon as it's available. Please be sure to have your first and last name as your screen name today. That will help us identify you for the CLE credit. And that's all for the housekeeping items. So let's get started with our program. Joining me today, I'm very pleased to introduce my colleagues Barb Grandjean, Julie Maselli, and Jackie Kaufman. Barb is the office managing partner in our Denver office, and she's with the Labor and Employment Group. She consults proactively with employers regarding workplace issues. Julie is also an office managing partner in our Chicago office with the Higher Education Group, and her practice is dedicated to serving private and public institutions of higher education. And finally, Jackie is an associate in our St. Louis office with the Labor and Employment Group, who also helps employers keep their workforces running smoothly. So although by virtue of our virtual backgrounds there, it looks like we're all in the same location, we're not. We're spread all across the country, just like all of you are, and we're very happy that you've joined us today. With that, I'm going to turn it over to my colleague Barb to begin with some of the legal and regulatory landscape related to digital accessibility.
Thank you, Elizabeth. And if we start just quickly with an overview of what we're going to cover for you, I'm going to go over the legal and regulatory landscape generally. Then what we're going to do is talk about how that applies to digital accessibility in particular. And then we're going to close with some compliance points for you to take away. So we're going to start with a poll question. And here we go. Has your institution developed a website accessibility policy or otherwise identified web content guidelines that it will use to test the website? Your choices are yes, no, or I'm not sure. The people who answer yes can just turn off the webinar right now because you've got it covered. The people who aren't sure need to stay. And I'm just kidding, of course. Okay, so it looks like almost 50% of you are conscious of this issue and have some plans in place. That's great to see. The 13% of you that don't, we're really glad you're here. And in particular, the people who aren't sure, we're excited for you to learn a little bit more about this. And actually, someone is suggesting they could say schmaybe. So schmaybe, we'll add that as a category next time. So next slide, please. And then the next slide. So if we start with the legal and regulatory landscape, we start with Section 504 of the Rehabilitation Act. This was signed into law by Congress in 1973. And it covers any entity that is receiving federal assistance. So we know that in 1973, Congress had absolutely no idea how to spell internet or what was coming. So the Rehab Act, Section 504, does not begin to address digital accessibility. But what it does say is any entity that's receiving federal assistance can't deny someone with a disability the benefits of or participation in any program or activity. I know that OCR has had some interpretation of Section 504, and that would be applicable to this audience. I wonder, Elizabeth, would you mind jumping in and just telling us how OCR views digital accessibility under 504?
Absolutely. As Barb mentioned, and we'll talk about throughout the presentation today, we're very happy to have Barb and Jackie with us as well, because this is an issue that obviously spans across industries. But we know that for all of you on the call, that educational institutions who fall under the jurisdiction of OCR's enforcement looking at some of the letter of findings from OCR sort of dictates how OCR has interpreted their jurisdiction over web accessibility, digital accessibility under Section 504. And those letters of finding talk about the broad non-discrimination provisions under 104.4 and walk through each of the subparts that they interpret as applying directly to access for students, as it relates to web accessibility and digital accessibility.
Great. So if we could go to the next slide. And we fast forward about 15 years to the Americans with Disabilities Act, which turned 30 years old this year in July, and it was signed into law by George H.W. Bush, who still had no clue what was really coming with the internet, the president or Congress. And so the ADA decidedly does not talk about internet or digital accessibility. Title I is one that I work with quite frequently. It's the employment relationship for private entities. Title II, which is the subject of today's presentation in part, prohibits disability discrimination by public entities. And so again, as we saw with the Rehabilitation Act, public entities can't exclude a person with a disability from services, programs, or activities of that public entity. That would be discriminatory. The regulations implementing Title II of the ADA are similar to those implementing Section 504, but Title II adds an extra component, which is a communications requirement. So a public entity under Title II of the ADA has to take appropriate steps to ensure that communications with applicants, participants, members of the public, and companions with disabilities are as effective as communications with others.
Barb, before we move on, I just got a question that I think might be helpful for us to cover now.
Okay.
Oddly, it's one that I think I might be able to answer for everybody. It's the difference between Section 504 and 508. Substantively, they're very much the same, just for all intents and purposes, but 508 specifically applies to federal agencies. So when I used to work at the U.S. Department of Education, it is the law, part of the law that requires those federal agencies to maintain compliance in the same way with respect to disability accommodations in the same way that Section 504 does.
Great. Thank you. And so if we can move to the next slide, where we have Title III of the ADA. And this is the title that deals with places of public accommodation. So you may be a public entity under Title II, and you may also be a place of public accommodation under Title III. And so under Title III, individuals with disabilities, and this includes students with visual impairments, may not be discriminated against in the full and equal enjoyment of all goods and services of private colleges and universities as places of public accommodation. They have to receive equal opportunity to participate in and benefit from those goods and services, and they must not be provided with different or separate goods or services. So, separate is not equal, unless doing so is necessary to ensure access to the goods and services to make sure it's equally effective as that provided to others. So as you'll hear when we go through this, places of public accommodation is really where a lot of the case law starts to focus when we talk about the internet. So is the internet a, quote, place of accommodation? So before we get there, though, certainly colleges and universities are, there's a list in the regulations that include things like movie theaters, schools, daycares, recreation facilities, hospitals. But again, when you're talking about a digital implementation of one of those places of public accommodation, that's where a lot of the law is focusing. If we can go to the next slide. To follow up on Julie's comments, by 1998, Congress has amended the Rehabilitation Act to include Section 508. So similar to 504, it prohibits discrimination based on disability, but Section 508 clearly does apply to electronic and information technology procured by the federal government. And so 508 is also a statute that is going to be applicable to the audience here as you're considering accessibility. So in January of 2017, the U.S. Access Board published a final rule that revises and updates the 508 standards and provides us with accessibility guidelines for telecommunications products and equipment. But entities, so the ADA doesn't talk about it, Section 508 does. And so entities that are subject to the ADA often look to these standards under Section 508 as a model for compliance, because there's nothing else really to look at. So that's what makes Section 508 important. And let me pause there to see if any of my higher ed colleagues want to piggyback on that at all. Okay, hearing nothing, let me move to the next slide then. And just as a reminder, you've always got to consider the state laws. From a liability perspective, California's Unruh Act creates a lot of interesting situations. California is obviously on the forefront of employee and student rights. So always be looking out for California. But in general, there are 48 states out of 50 that have some form of anti-disability discrimination laws that either mirror the ADA or they're more stringent. So in the case of California, for example, there are additional penalties available there to a plaintiff that are not available in many other states or under federal law. And then many of the states also have adopted legislation that relates to state government websites, for example, and the accessibility of those websites. And so I think it's 14 states in total that have passed some sort of legislation for their own websites for information communication technology accessibility. So with that, those are the high level laws, and I'm going to turn it over to Jackie, who's going to talk about the internet and websites in particular.
Great, thank you, Barb. So as you've just heard, the internet was really in its infancy when the ADA was passed. And so there's no mention of the internet in the law itself. Consider the list that Barb read just a moment ago. Businesses that are generally open to the public, including restaurants, movie theaters, schools, daycare facilities, recreation facilities, hospitals, and doctors' offices. Obviously, the word website is not mentioned there. There's no consideration of it. So the question is, are websites a place? And unfortunately, right now, the answer depends on where you are located, because there's a circuit split that we're going to discuss momentarily. And ideally, Congress would address this question. And a bill was actually introduced in February of this year in an attempt to do so. If we can move to the next slide, please. So in February of this year, a bipartisan group of representatives reintroduced what is known as HR 1100, or otherwise known as the Online Accessibility Act. And the act, which was initially introduced in 2020, but unfortunately died in committee, would amend the ADA to include an additional provision, a Title VI, called Consumer-Facing Websites and Mobile Applications Owned or Operated by a Private Entity. And Title VI would require any consumer-facing websites or apps to be in substantial compliance with the WCAG, or Web Content Accessibility Guidelines, which Elizabeth is going to discuss with you in just a little bit. Or would have to provide an alternative means of access for individuals with disabilities that is equivalent to the content available on the website. So this would provide some much needed clarity on what is required of businesses who are struggling to interpret existing ADA guidelines. And it would also institute some administrative remedies that would need to be exhausted before a lawsuit could be brought in court. But unfortunately, we haven't seen much action on this resolution. It was last referred to the Subcommittee on Consumer Protection and Commerce in February, and it seems doomed to die again in committee, unfortunately. Next slide. Thank you. So on the court front, we have seen a split in circuits in how they interpret the ADA as to whether it applies to websites. And as you'll see in a moment, courts are all over the place on this issue, but the holdings can generally be sorted into two main camps. Those who assert that websites are not places of public accommodation, full stop, and those who assert that they are. And on this sliding scale, some courts state that websites are only places when certain conditions are met, such as when the website has some sort of physical nexus to a brick and mortar location that itself falls under Title III of the ADA. Next slide. So pictured on the screen here is a continuum showing where some of these courts fall. And this is just a smattering of recent cases, but you can see courts are all over the map. Nobody's really sure what to do. Compare even the Eastern District of Virginia, which you can see on the far no end of the scale, to the Western District of Virginia, which you can see on the far yes end of the scale. Totally different outcomes within the same circuit, even within the same state. Next slide. Thank you. So of course, courts differ on this issue. We're going to discuss a couple of the cases here that found that websites are not places of public accommodation under Title III. The first one is Gill v. Winn-Dixie Stores. And this is just from earlier this year, just a few months ago. And in this case, like in most of the cases that we are seeing in this area, a legally blind individual brought an action alleging that the website owned by Winn-Dixie was not compatible with screen reader technology. And that's a really common allegation in these suits. But here, the court found that because the ADA's expansive list of places all included physical locations, that a website simply did not qualify as a place. And the court also refused to adopt a nexus standard. And then a little bit earlier in Carroll in the Eastern District of Virginia, and this was just at the motion to dismiss stage, the court found that the plaintiff hadn't stated a claim for relief based on his inability to access the defendant's website because websites are just not places of public accommodation. Next slide. Websites also can be places of public accommodation, and these are cases that fall a little bit in the middle of the spectrum here. So under Mahoney, the plaintiff sued and alleged a violation of Title III because the defendant, who is a snack food company, their website was incompatible with that screen reader technology. And again, at the motion to dismiss stage, the court found that because the defendant's website by itself is not a public accommodation, and because the plaintiff hadn't alleged any nexus between the website and the defendant's physical location, that the complaint failed as a matter of law. And then the Robles v. Domino's case. This case gathered a lot of attention. And I've cited here Robles 1 because that was the first time this case went up to the Ninth Circuit. And it found that Title III applied to Domino's website and to its mobile app, and that the website and app were two of the primary means of ordering the operator's products or the pizzas to be picked up at or delivered from pizzerias, which themselves are places of public accommodation. So this court did require a nexus between the website and a physical location. But note that in Robles 2, which came out just earlier this year, it had gone back before the Ninth Circuit, and they held that the franchisee ownership model did not serve to break that nexus. Which is a really interesting point because Domino's corporate, of course, owns the website and they own the mobile application. But each individual pizzeria is owned by a franchisor or franchisee. So the defendants had tried to argue, well, we don't own the website, so how could we be liable for that? But the court did not. The court did not buy that argument. And here we have just a couple of cases that found that websites are places of public accommodation under Title III. So the first is the National Association of the Deaf v. Netflix. And in that case, the court took sort of an interesting approach. Despite the company's contentions that the ADA didn't include those web-based services, the court said that Congress did not intend to limit the ADA to specific examples listed in the categories that Barb read just a few minutes ago. And they also found that websites fell within at least one, if not more, of those enumerated categories, including service establishment, which is sort of this vague catch-all, in that Netflix was a service establishment because it provided customers with the ability to stream video programming through the internet. And here, even though the home is not a place of public accommodation, of course, it's private within the meaning of the ADA, entities that provide services in the home might qualify as places of public accommodation, which is a really expansive reading, and the only district court so far that has taken that expansive of a view. But in Mexico here, Western District of Virginia, just earlier this year, the online retailer's website did in fact constitute a place of public accommodation because it was not accessible to that screen reader technology that we just discussed. And this court also found, although online retail businesses are not expressly mentioned in the ADA, the terms in the ADA didn't require public accommodations to have a physical structure for persons to enter. And due to the prevalence of the internet, excluding those online retailers and commercial websites from the reach of the ADA would have frustrated the purpose of the ADA, which is to ensure individuals with disabilities fully enjoy the goods, services, privileges, and advantages that are available indiscriminately to other members of the general public. And this is, again, one of the most expansive readings that we have seen of the ADA so far, because this was a totally online retailer. They have absolutely no physical stores, no physical presence, but the court did find that the ADA applied to them. And now I believe Elizabeth is going to discuss the increase in complaints and suits in higher ed.
Thanks so much, Jackie. That was great. So first, just want to address a question that we had related to the distinction between how public and private institutions might be treated in this space. And I think broadly, the obligations are very similar. There are obviously differences in some of the language under Title II and Title III. So you have to kind of pay attention to whether Title II applies to you as a public. With respect to OCR enforcement, though, as long as an institution is a recipient of federal funding, 504 is going to apply and OCR is going to have jurisdiction, regardless of whether it falls under Title II or Title III. As many of you know, OCR doesn't have enforcement jurisdiction over Title III, but again, under that umbrella, under 504, which applies, we suspect, to the vast majority of all of you, OCR will have jurisdiction in this space. So as Jackie laid out so eloquently for us, of course, these cases are being resolved very differently across the circuits. What is clear is that there has been a significant increase in the amount of complaints, demand letters that institutions, that companies are getting across the country, and enforcement in this area. And again, they've been submitted across industries and including, of course, in the higher education sector. As for the history of these suits against higher education institutions, advocates for individuals with hearing impairments initially sued Harvard and MIT in 2015 for failing to capture online lectures, courses, and other educational materials. It went through litigation. There were motions to dismiss. In response to those motions to dismiss, the court did rule that federal laws prohibiting disability discrimination covered these aspects of Harvard's education programs and activities. After those rulings, Harvard announced its new digital accessibility policy in 2019, and the parties reached a settlement. So we didn't get the creation of any more law out of those, but there was a settlement as a result of it. And then, of course, over the last 6-7 years, there have been just a series of complaints and suits filed, a large number in New York. We've seen a great deal of suits filed in New York against educational institutions, many that are being kind of filed in mass. For example, one particular plaintiff, as of this month, had filed a total of 145 suits in the Southern District of New York from early 2020 to the present. And so just an example of the kind of uptick in this litigation. And sort of similarly, many of you on the call may have been involved directly in some of the mass filings that OCR has received as the result of disability rights advocates, putting institutions' websites into kind of online accessibility checkers and filing complaints in mass about the accessibility of the websites. There's been sort of a course of how those have been treated at OCR. Many of them were dismissed initially, but then reopened. Some have been, successfully resolved through remediation on the part of institutions. Some have resulted in 302 agreements through OCR's voluntary resolution process. But what's clear, this has certainly been an area of emphasis for OCR, and we think that this will continue. Many of these cases, I think as a result of these cases, there has also been the establishment of a national digital accessibility team at OCR sort of a team of investigators and attorneys that have been trained with respect to this area in particular. And so we do anticipate that this is an area that will, continue to be an area of enforcement for OCR. Next slide, please. And then in addition to OCR enforcement, we also wanted to highlight the recent OCR guidance as a result of COVID-19 and the pandemic. Because in large part, there were areas that did relate to 504 and Title II compliance, which was to say that the institution's obligations with respect to Section 504 and Title II remain despite the pandemic. I think there was some acknowledgement within the guidance that institutions were hard pressed, at least initially, certainly, to pivot to their pivot their educational offerings as a result of the pandemic. And OCR addressed that by saying that institutions should not decline to provide distance education out of fear that they must first address all matter of accommodations for students with disabilities. Certainly that obligation remains and needs to be addressed, but some acknowledgement that there might take a bit of creativity and time to make sure that all of those access needs are met in the course of providing that online learning during the pandemic. But again, as I said, at bottom, it really did re-emphasize institutions' obligations to provide academic adjustments, auxiliary aids and services, and reasonable modifications for students with disabilities. Next slide. We wanted to, while we won't be addressing electronic information technology beyond these few slides, we wanted to make sure that we highlighted the issue of academic technology, and that this issue broadly of digital accessibility goes beyond access to one's website. When we talk about a place of public accommodation and the case law that Jackie went through, we're really talking about the access to the website and whether that is a place of public accommodation. But as academic institutions providing these various technologies and various types of access to education curriculum, these are areas that clearly need to be addressed and can't be overlooked when considering non-discrimination and accommodation requirements. Next slide, Julie. Thank you. And when we think about this issue of academic technology, the most often, and I think first really kind of referred to OCR guidance is the Kindle DX case. And in that case, a number of institutions had implemented the use of ebook readers, the Kindle DX at that time, as a replacement for traditional textbooks. And it did not have full text-to-speech technology. And there were also some barriers. So there was some limited access to content in that way. And there were also some navigational barriers related to the menus and when individuals with visual impairments were trying to navigate through the course materials themselves. And in this matter, and then in a subsequent Dear Colleague letter, OCR laid out, that without this access to the menu and navigational control, the functionality and the access was limited in a way that was unacceptable under Section 504 and the ADA. And so really kind of defined for institutions that as emerging technology is being considered and implemented, issues of access for individuals with disabilities must be considered. Next slide, please. And then here we've included this. It's a little dense, but we just wanted to highlight for you some historic OCR agreements have demonstrated how the agency defines electronic information technology. And if you compare some of the resolution agreements where institutions had to adopt such new definitions, adopt policies and procedures related to these issues, you can see how they vary. So this definition comes from a University of Montana Missoula agreement There are others where the definition is more limited in its application. So, for example, instead of all of these various aspects of information technology, it's more limited to the website, online learning, course management systems. So I think it's something to consider when, for those of you that have already developed such policies, perhaps when you're revisiting them and kind of reconsidering definitions, this might be something to keep in mind. And certainly for those of you who have yet to develop policies in this way, as those of you who know or are very involved in policy development, the definitions are obviously critical in talking about what the institution is committing to, and the scope of these types of policy application. So would just encourage you to kind of consider, comparing some of these definitions when doing that. Next slide, please. And next. So now we'll just spend a bit of time talking about the WCAG standards. And, this is really the area where institutions have to kind of dive into the weeds about what constitutes compliance, what constitutes compliance and what constitutes accessible access. Here, your internal tech talent is going to be very important. Additionally, external consultants or resources can be extremely useful in making these determinations about how to actually define access. As Barb and Jackie both mentioned, under Title II, Title III, Section 504, there are no specific standards for how to define website accessibility. And in fact, many entities have tried to argue that in the absence of such regulatory guidance, entities can't be held responsible for not having that access. By and large, that argument has not been successful because of those broad requirements for non-discrimination that Barb highlighted. So anyway, but in the absence of regulatory guidance, the WCAG standards are the generally accepted set of guidelines for web accessibility. As Barb mentioned, they're the standards that have been adopted explicitly under Section 504. They're also the standard that courts have often required in settlement agreements or in judgments about what has to be implemented. And they're also the standard that many of you have probably already adopted or will adopt in the development of policy. So what WCAG is essentially, it's a consortium of the international community of experts who have worked together to develop these standards for what it means to have a web that is available to all. And so we'll spend just a few minutes talking about kind of the categories broadly. For those of you with limited experience related to digital accessibility, this will provide some kind of high-level guidance about these issues and what they require. So there are 4 principles within WCAG: perceivable, operable, understandable, and robust. So perceivable means that a person can access the information through their senses. So for example, if someone can't see color images, what are they missing in terms of content communication? Operable means it talks about navigation. So provides ways for users to navigate, find the content, determine where they are on a page. This is really all about the structure of a web page. Understandable in information and the operation of the interface must be understandable. A lot of this is about language and about predictable operation of pages. And then finally, robust. These are some of the principles that talk about how the website should operate as new technologies develop. So through the development of these standards, we've had WCAG 2.0, and now we have 2.1, which is the new gold standard. It was recommended in June 2018. It contains all of the same success criteria as 2.0 plus 17 additional criteria, and also addresses mobile accessibility, which is, of course, a whole different category from desktop, web access. And then finally, just a mention on ARIA. ARIA is a W3C, which is, again, the consortium that develops WCAG. It's a specification to ensure that web applications remain accessible as they become more dynamic. Again, that is an area for those with significantly more, tech experience and expertise, but is yet another way to demonstrate accessibility and test for it. Next slide. So again, just want to talk through kind of a few high points related to compliance in this area. So number one, when you're thinking about, how to train your teams or to get institutional buy-in about this issue, I think the most important thing is to consider, the broad importance of your institution's website and what the vast amount of information that you're trying to convey and the importance of what it conveys. And broadly speaking, when it comes to barriers, information may be accessible to individuals with visual impairments who have blindness, low vision, or color blindness, hearing impairments who have deafness or are hard of hearing, or mobility impairments, those who have the inability to use a mouse or otherwise have limited fine motor control. And so these are all ways that websites can include barriers for individuals. There are a lot of, when it comes to individuals with visual impairments, there are a lot of videos available showing kind of effective and ineffective structure when it comes to screen reader use. These videos, again, can be really helpful, I think, with respect to training your teams, and then also, as I mentioned, getting institutional buy-in about how to prioritize this issue on your campuses. Next slide, we'll just go through a few of these again at a high level. So clear visuals, it requires that non-text content must have a text alternative so that it can be read by a screen reader. In our work with institutions in this area, often I think, with some exceptions, but often I think alt text is really considered kind of low-hanging fruit for institutions as they're trying to increase their compliance in this area. So images including alt text, colors shouldn't be used as a navigation tool, again, for individuals who may have color blindness. And then also contrast issues. Color contrast is an issue that frequently comes up in some, both in automated and manual checkers with respect to institutions' website. There can often be design and school pride kind of counter arguments with respect to contrast issues. But I think it's an important issue because it often does result in issues getting flagged for institutions' websites. Next slide. Next, with respect to supplemented audio and video, so this is also a perceivable requirement. Captioning for video, transcripts for audio. Many of you are probably familiar with the idea of universal design, which is to sort of, I'm paraphrasing here, but it's the idea that some of these issues are required for individuals with disabilities, but enhancements in these areas can really have broader application and ease of access for all. And so transcripts and captions is I think an area that where universal design applies, particularly as those of us, we've all been sort of transitioning to more kind of online use. Transcripts and captions can be useful broadly, to individuals as they're trying to access content remotely. And so those are issues related to audio and video. And this is also an area where when you are considering procurement, looking for assurances from vendors about issues related to captioning and transcribing that will assist you in providing those resources. Next slide. This navigation issue relates to the operable principle, being able to interact with information, and again, applies most often to individuals with mobility impairments who use keyboard navigation to access content on websites. This was an area that was, I think, of high priority with respect to many of the OCR investigations related to web accessibility. And this is really about the markup of a page behind the scenes. So where you'd be relying again on your web developers to kind of structure the page so that there is better navigation with respect to the keyboard. And then also how it is structured with respect to headings, subheadings, and lists. So that it's more effective for a screen reader user to be understanding and accessing the content. Next slide. And then the last category here relates to understandable content. Again, relates to language being designated and making sure that it's presented in a predictable way. So that it is more understandable. And this is, again, another set of standards under WCAG. And then next slide, please. Finally, we'll talk about accessible forms and files. Many of you today may have been involved with digital accessibility enhancements on your website or with your course materials. Even those of you who have not been know that PDFs can be a particular compliance concern, especially in academia, because of the broad use of them, in terms of how publications are released. PDFs often have inherent accessibility issues that make them inaccessible to screen readers. And so PDFs are an important area of focus. And then forms as well. We, as institutions, you need to make sure that when you do have a form on websites, that those are also accessible. This is an area where often institutions can run into issues because they're using third-party servicers for some of these forms. And so you might not have as much control over the accessibility of the form. But first and foremost, with the forms that you are providing, you obviously want to make sure that those are accessible, and then it may take some additional kind of interfacing with vendors to try to increase and address accessibility issues with forms and files on the websites.
So Elizabeth, can I add one thing there? I'm really struck as we're talking through all this, the importance of making sure folks recognize that this isn't just a one and done. You don't just come into compliance and then you're there. It is a constant battle and you constantly have to stay on top of it. Everything new that you do has to be compliant. So it's really an ongoing big project.
Yes, it is. And that's a beautiful transition over to Julie, who's going to talk about some compliance points and best practices as institutions, commit to and continue their work in this area.
Yes, thank you. I have big shoes to fill. That's been a lot of information and extremely helpful. I've been having a good time tracking the conversation and responding to all the questions I've been hoarding. Why don't we start this section on compliance with 2 poll questions? So I'm going to go ahead and launch the first one right now, which is, does your institution have an internal process for complaints? As we talk about compliance, hopefully we feel very good that we're moving forward with the compliant offerings on our website and with our digital technology. But if we're not, if somebody's got a concern, is there a complaint process? I'm going to end the poll in 3, 2, 1 and share the results here. Good. What I'm seeing is there's a strong majority of you who do have a complaint process for concerns. Some of you aren't sure. And we're going to get into why that's important in a moment for you to know. And then about a third of you out there, I don't know. So we're going to talk about what that process should look like in a moment. But let me go ahead and ask you another question before we start this conversation. Has your institution received an external or internal complaint? So yes, it's good to have the actual process, but have you had an opportunity to experience that process, that policy through an actual complaint? You have a number of options here. And I will end the poll in 3, 2, 1, and share the results here. Really interesting. Almost half of you aren't sure. A good chunk of you, over a quarter, have not received a complaint. And then there's I guess about 30% of you who have had some kind of an internal or external complaint. Compliance, hopefully, is a proactive, preventative activity that you're engaged in, but certainly it can be a reactive activity as you are responding to complaints. So let's talk a little bit more about compliance. So how do we ensure we're compliant, particularly back to a point that Barb made, which is that when you're in a fluid environment, everything in the internet, web-facing, digital accessibility, anything related to technology is by definition dynamic. It changes moment to moment. So how do we get ahead of this? Well, what I would say is that if you're trying to get ahead of standards and get ahead of your technology and get ahead of your IT team, you're going to set yourself up for failure. So let's set ourselves up for success by saying, let's figure out what we have and take inventory of what we have already within our website, within our digital communications tools. So assess your own web presence. That's the first place to start. If this feels daunting to you, Elizabeth and I are going to tell you, all of us are going to tell you, this can be done. We do it with institutions all the time. And it feels daunting and a lot of folks don't know where to start, and this is the place to do it, is take inventory. How many websites do you actually have as an institution? Do you have third-party websites that are essentially run by somebody outside of your institution on your behalf? Are you engaged as an institution actively on social media? At one point, you may have had every single one of those social media icons that are listed here and using them regularly. And as time goes by, those start to move. Folks aren't on MySpace anymore. I wonder if your institution still has a MySpace page, but you probably have a Facebook page or a do you have a YouTube channel? So what are you doing on social media through other platforms? And what information is being provided? To the point about universal design, why are we even on the website? There's marketing goals, there's enrollment and admissions goals, there's PR goals, there may be fundraising goals. There's always a goal tied to where you are. We really want to understand what websites are fulfilling what needs of your institution. And then also what functions are offered through the websites. How are you interacting with students, employees, members of the public, donors, alumni? Those functions, when you're actually interacting, collecting information, being in a position to download information and give them, we need to understand all of that. So these are the 5 bullets that I would say that if you're starting from scratch and you don't feel like you've looked at this either recently or at all, these are the questions you're going to want to start to take inventory on and really get a good understanding of what do you have and what your web presence looks like. So once you gather that information from an internal team and any external partners, including those third-party vendors that may be out there running a website for you, we need to figure out, do we have the talent, the skills, the interest internally to address compliance? So if we go into this thinking, if we haven't addressed it, we're going to have some gaps. We don't know right now how big those gaps are. Do we have folks in-house who either already have some familiarity with the technical standards, with YCAG 2.0, this isn't completely foreign to them, or at least have the interest and the drive and perhaps some talent that they can lend to learning this and really taking it on? If not, then where can we find that kind of talent? And can you go maybe outside of your central IT team or your accessibility team, your ADA group? Can you find that in other pockets across the university or the college, or do you need to bring somebody in? Also, a big question to ask yourselves is, how decentralized are your operations with respect to your web presence? Is everything being run internally to one department? Or do you have a very organic web presence where even the chemistry department and the music college all have their own sites that are being run by those business units? Because if that's the case, any effort's going to have to find a way to bring them all in under the tent. Now, there is a lot of really good marketing and consistency reasoning and PR reasoning from a web perspective to bring that in a more centralized way anyway. So a lot of schools that we've worked with are actually pretty excited about that. Now, they don't want to kind of trample on that local control feel in a decentralized system, but there's a lot of benefits, and it could also be cost effective to do it in this way. So you just got to figure out how big is your tent and how many people do you need to pull in, or do you have the benefit of starting from a centralized post to begin with? And then the next place after you've taken some inventory is realize you're going to need to embed consistency. If you're going to try to meet these compliance standards, you're going to need to have a policy. That is how we ensure consistency across an institution. It also is a compliance requirement in and of itself. You'll need internal procedures that address all of these issues that Barb and Jackie and Elizabeth have talked about already. So you're going to need a website accessibility policy that all of those little tents can use as their guide for following, and also internal controls to maintain accessible features. Getting ahead of it and being preventative is great, but we started this section talking about complaints. You have to have a place where individuals can raise concerns or complaints. I'm trying to access this and this navigation is off, because even if you put in place the most compliant system, every one of your websites and navigation features are all compliant, you have the right alt tags, you have the right color contrast, something at some point gets uploaded and we just miss a fillable form. One of our PDFs is wrong. We actually need our community to help us stay compliant. That's part of it, is that we actually team up with our community through a complaints process. And so that's another part of your policy and procedures that you're going to need to build out, which is, what does that complaint process look like? How much process are we giving to those? What is the process for elevating those and remediating those concerns when they bubble up, to make sure that even in this very dynamic world that we live in with technology, that we can not just get ahead of it on our own, but we can use our community members to help us maintain compliance. We also have to evaluate the content of what's on the web, not just what sites are out there and who's controlling it, but actually what is being posted. The universal design mindset is key. There's a lot of content on there that we may not even need, or it's not really user-friendly, irrespective of whether we're serving individuals with disabilities well. We may not be serving any user well with the way that we've put content up. Is it logical? Does it give us and convey the information that we're trying to communicate? So we like a lot of manual checks. After you have looked at your content and tried to make some changes and adjustments, hey, we realize all of our color contrasts and these 6 kinds of pages are wrong. We're going to fix them across the entire enterprise of what we offer. Do a check. Make sure somebody else outside of your team can get on and do a little bit of checking to make sure that that cleanup actually is stuck and it's fixed, and we don't have problems. If you're really running into trouble or don't have enough internal capacity to manage it, there's consultants out there that can help you with it. We actually partner when we do these for a lot of our clients with a nonprofit technical expert. So Elizabeth and Barb and Jackie and I can go in and advise on the policy and the procedures and the legal aspects, and if you have a complaint and what that process needs to look like. And we've learned a lot that we can get on a website and pretty quickly identify some problems, but we're just the lawyers, and we always rely on technical experts, particularly when we're dealing with new and emerging accessibility issues. Some of you all are getting really creative. I've seen schools who are online right now that are using AI, artificial intelligence, to have little fake people talk like holograms to their future students about what it's like to be a student here. And we have, so there's bots out there, and we have technology popping up on campus that will help people identify where they need to go. And you've got an app and a map on your website that will track you from a GPS perspective, and just really neat new technologies that are great for users, but that will start to get a little bit out of our own depth, and we need to call in the experts for those sorts of things. Another, it's not on here, but a compliance point that I love is share the burden. Make sure your vendors, your third-party contractors, the folks you're buying technology from, you have requirements in your procurements that they are also on the hook for making sure you're compliant. It is going to have to be a cooperative experience. You can't just delegate it out to your vendors, but they certainly should be at the table, and they should be promising you they're going to do what they need to do to get that technology you're buying compliant with your expectations. And always, always look for template fixes and trends. If you have a decentralized web system where all these different departments and business units may pull out a template and then do their own website, at least fix those templates so that anything anybody's utilizing gets implemented in a compliant way enterprise-wide. Prioritize remedial efforts. I know for some of you who haven't tried doing this yet, it may feel daunting, and I can't tell you how easy it is and quick you can get some really big ticket successes, and a few wins breed more wins. So start with the easier things, address the low-hanging fruit. Color contrast is something that's usually pretty easy to address. Captioning for videos that you have is something that usually is, you're going to find one way to do that, and you're going to be able to apply it everywhere. Those are the kinds of things that are easier. Navigation may get a little bit more tricky. You may need more skill sets to deal with some of those trickier issues. Start with the things that you can do well and do quickly, and start there. It's dynamic. You want to, you're not going to have all of the legacy content on your website all made compliant in 3 months. But what you may have are all of your templates made compliant and all of your key pages made compliant within 3 months. That's a great goal to get you started.
So Julie, I was just going to say, in my experience with litigation, that low-hanging fruit is really important too, because you don't want to be the easy one for the plaintiff's lawyer. You want to look like you know what you're doing, at least enough that it's not going to just be a shakedown if they reach out to you. So that's the other reason to really take care of that low-hanging fruit and get the accessibility statement on your website.
Yeah, I couldn't agree more, Barb. The greatest defense you have is an effort that you're on it. You have a policy, you have procedures, you have a complaint process, and you are working towards compliance, and look at all the things we've been able to do. Yeah, we don't have these 15 archive website pages and all these PDFs yet fully compliant, but that's legacy content. That's not actively important right now for how we communicate with our students, but all this is, we've prioritized. I couldn't agree more. Train content editors. You're gonna have to, I know campuses just don't have a digital accessibility team all there ready to go. This is something you have to organically build. And one of the best ways that we found through our experience with lots of institutions who are either doing this because they've been threatened with litigation or they're preventatively trying to get ahead of it, is that they will build from a train the trainer model. So they will put some systems controls to ensure consistency. They will train a team of web content editors, and those folks will then train their folks, particularly in decentralized ways. And there's got to be continued efforts to keep that education current. So as you add new web content folks, bringing them in at least annually, if not a couple times a year, to make sure everybody's on the same page. Make sure you have somebody who is going to oversee this, some kind of coordinator who can make sure that the complaint process is working itself out properly the way that you planned, and if not, making modifications when those are needed. And also that all of the preventative work on the tech side is actually occurring. Somebody's got to take the lead. I always think about that as someone's responsible for the deliverables and someone's accountable to the institution for making sure that everybody's doing what they need to be doing. So we are very close to the end of time. I know we have about a question or two. Elizabeth, if you can see the chat, if there's been any teed up for me or a few that we need to tee up for everyone in email, we're happy to do that too.
We have a few questions about VPAT agreements, with some weighing in on their usefulness, which I think is, some people have had that experience that they aren't terribly useful. I think Julie's point is the most important, which is that during that procurement process, that there is some sort of engagement during that negotiation about what your vendors will commit to. And they are going to have to be partners in it, depending on who's got the ownership over the particular content. So
yes, you need good procurement language if you don't have it already. Okay, so I see that we are at time. We are going to go ahead and wrap up. Just a few little housekeeping points is, yes, we have committed to providing out these slides. We developed them so that they are a guide for you and your institutions. I was saying we'll get them out in 24 hours, which is usually true with our other webinar technology. It will be out hopefully by no later than Monday. So excuse me if it's a little later. We usually turn these around in 24 hours. We have webinars every month for free to institutions of higher education and our friends out there. So feel free to sign up. If you have any questions, please let us know. Elizabeth, any closing comments?
We will also be sending the CLE certificate and a link for reporting in Illinois, Kansas, Nebraska, Tennessee, and Texas. And that will be forthcoming. And then, as Julie mentioned, we will be sending an accessible version of the presentation as soon as we possibly can. Please remember to complete the survey if you have an opportunity. It helps us to provide quality content for all of you in the future. And our next webinar is November 30th, and we'll cover pregnancy discrimination. So thank you all so much for joining us today. We hope you have a great afternoon.